Welcome back to Death Row Cases. On Monday, we told the first part of the story of Dominick Occhicone, how in the early morning of June 10th, 1986, he murdered the parents of his ex-girlfriend Anita Garrity in their home in Holiday, Florida. How he first knocked on her bedroom door, left, and came back an hour later with a handgun, cut the telephone lines, shot her father Raymond, broke through a closed door, and shot her mother, Martha, 4 times. How he was tracked down within hours by a police dog, and how a jury, by a divided vote of 7-5, handed him the death penalty for the murder of Martha and life for the murder of Raymond. Today, what happened after that sentence became final in the early 90s. And I'll say it up front, it took more than 30 years for this case to come anywhere close to an ending. For anyone joining us for the first time today, here are the essentials. Dominick Occhicone was convicted of the murder of Martha and Raymond Artzner, the parents of his ex-girlfriend. The jury recommended the death penalty by a non-unanimous vote of 7-5. The Florida Supreme Court affirmed that, and in 1991, the conviction became final. That's almost never the end in an American death penalty case. It's more like the beginning of a second, much longer phase, one that, in Occhicone's case, would run for more than 3 decades. This case moved through decade after decade of appeals once the original sentence was handed down. And as you'll hear by the end of this episode, Occhicone's execution date carries its own grim distinction for the state of Florida. But let's start at the beginning of the appeals. In July 1992, Occhicone filed a petition for a writ of habeas corpus, arguing that the jury instructions on 3 of the aggravating circumstances were unconstitutionally vague. The court rejected it in April 1993. Then, in May 1993, Occhicone filed his first so-called post-conviction motion. That's the type of appeal filed after all the ordinary appeal options have already been exhausted. It's meant for situations where new information comes to light, or where the realization sets in that something went seriously wrong during the original trial. This first motion contained 7 separate arguments. I'll run through them briefly, because they give a good sense of how broadly these kinds of requests are set up, whether the prosecution had violated the Brady rule, whether his attorneys had provided ineffective assistance, both during the guilt phase and the penalty phase, whether Occhicone had wrongly been denied a competency evaluation, whether the jury instructions were unreasonably vague, whether his death sentence was based on an unconstitutionally obtained prior conviction, and whether all these alleged errors together had denied him a fair trial. I want to dwell a little longer on 3 of these points because they touch the heart of why this case, despite what was in effect a confession, has remained contested to this day. The first is the Brady claim. Under the Brady rule, prosecutors are obligated to share exculpatory evidence that could work in the defendant's favor with the defense. Occhicone argued that the prosecution had withheld the names of a series of witnesses who had seen him in the hours before the murders, and who could have confirmed how drunk he was that night, exactly the kind of witnesses who could have strengthened his intoxication defense. For 2 of them, according to Occhicone, it involved notes of police interviews that were never shared, in which those witnesses had stated that Occhicone had a buzz that day. There was even a bartender, Lily Lawson, whom you may remember from the previous episode as the witness, who testified that Occhicone had said he wanted to kill Anita's parents while she watched. She later gave a sworn statement claiming that before the trial, the police had put tremendous pressure on her, that they had made things very difficult for her, and that they had put words in her mouth, that they wanted her to testify a certain way and made sure she did. That sounds, when you first hear it, like a potentially explosive revelation. And yet in the courtroom, it did not hold up. The reason why is important to understand, because it comes back again and again in these cases. With a Brady claim, a defendant doesn't only have to show information was withheld, he also has to show the information was so important that you could fairly say it puts the whole case in a different light. The court ruled it did not. No one, the court reasoned, could know better than Occhicone himself, whom he had met that evening and where he had been. So those witnesses were never truly hidden from him. Lily Lawson's statement, however unsettling, was not the only indication. There were multiple other witnesses who testified, independently of her, about Occhicone's hatred for Anita's parents. And there was that other independent evidence of premeditation, like the cutting of the telephone lines. This pattern, where an unsettling fact in itself is still weighed away because the rest of the evidence stands, is something you see in virtually every long-running death penalty case. It's precisely what makes it so hard for a defense to break through with anything, even when things have gone wrong that seem serious at first glance. The second point I want to dwell on is the claim of ineffective assistance of counsel. The idea that a defendant has a right to a thorough defense, and that if an attorney did too little at the time, that could have unfairly influenced the outcome. What makes this case so interesting is that Occhicone's later attorneys didn't so much attack the strategy itself, but the way it was carried out. The defense had chosen to bring out the evidence of Occhicone's drunkenness, mainly through cross-examination of the prosecution's witnesses, rather than calling a series of its own witnesses. There was a calculation behind that, one explained at length, during a later evidentiary hearing by the attorneys themselves. In the American legal system, the side that presents no evidence of its own has a strategic advantage in the final phase. It gets to address the jury both first and last, right before deliberation. Occhicone's attorneys did not want to give up that advantage. They believed they had already brought out enough evidence of drunkenness through cross-examination, and that it was more valuable to keep the last word. There was something else at play, too. If the defense called its own experts to testify Occhicone had been incapable of premeditating the murder, the prosecution could counter with its own expert, Dr. Mussenden, who had examined Occhicone. And the problem was, during that examination, Occhicone had described the details of the murder night to that expert vividly and in detail. A detailed memory that sits poorly with the picture of someone too drunk to know what he was doing. The defense feared, in other words, that calling their own experts would open the door to evidence that would undermine their own case. Years later, something remarkable happened with that same prosecution expert. After Dr. Mussenden read the new sworn statements filed during the appeals, including Lily Lawson's, he changed his opinion. He stated that if he'd had that information at the time of trial, he would have testified differently, more in Occhicone's favor. That is, when you think about it, a telling moment. The prosecution's own expert, who, with the benefit of hindsight, reaches a different conclusion. And yet even that was not enough to make the verdict tip. Because here, too, a high bar applied. To overturn a conviction for ineffective assistance of counsel, it's not enough to show an attorney could have done something differently in hindsight. You have to show the chosen strategy fell so far below the professional standard that it's realistic to assume a different approach would have led to a different outcome. Courts are extraordinarily reluctant to condemn the strategic choices of the past with the knowledge of the present. An attorney is not ineffective, the settled reasoning goes, merely because later attorneys would have handled it differently. The court found the defense had followed a deliberate, considered strategy and rejected the claim. The third point is that of the prior conviction, and it's a fine illustration of how firmly anchored an established aggravating circumstance can be. Occhicone argued his death sentence was based in part on that one prior conviction, the one for resisting arrest with violence, which according to him had been obtained in an unconstitutional way. The court rejected this for two reasons. First, Occhicone had never separately challenged that prior conviction, and had also not explained how it violated his constitutional rights. But second, and this is the point that really matters, the court ruled this aggravating circumstance would have stood anyway, even without that old conviction, because the simultaneous conviction for the second murder, the one of Raymond Artzner, on its own already satisfied the requirement of a prior violent conviction. Think about that for a moment. Even if you set aside that conviction for resisting arrest entirely, the court could have established exactly the same aggravating circumstance, purely because Occhicone had, in the same trial, already been found guilty of a second murder. One murder thus strengthens, legally speaking, the sentence for the other. That kind of reasoning, where a court, in effect, says, even if you were right, the outcome wouldn't change, makes the bar for a successful appeal even higher than it already is. The court rejected most of these points outright, held an evidentiary hearing only on parts of the ineffective assistance claims, and rejected those too in the end. In the year 2000, the Florida Supreme Court affirmed that denial in full, and then Occhicone went to the federal courts. In November 2001, he filed a federal petition for a writ of habeas corpus. It was denied in March 2005. But in November of that year, the federal court granted permission to appeal on one specific issue, a possible violation of what in American law is called a Giglio violation. Giglio plays the leading role in this part of the story, so let's explain it properly. Giglio, named after the case Giglio versus the United States from 1972, is closely related to the Brady Doctrine. Where Brady is about the withholding of exculpatory evidence in general, Giglio focuses specifically on information that undermines the credibility of a witness, especially when that witness has a deal with the prosecution in exchange for testimony. If a prosecutor knows a witness has such a deal and doesn't correct it when that witness denies the deal's existence under oath, that is exactly the kind of violation Giglio addresses. In the Occhicone case, this all revolved around a man we'll call Baker here. Baker shared a cell with Occhicone after the murders, and according to Baker, Occhicone told him something incriminating in that cell, that the only mistake he'd made was that he hadn't killed Anita too, and that her parents, in his words, were people he should have shot a long time ago. Baker testified about this, both in a pretrial deposition and at the trial itself, and here it becomes problematic. At the moment the prosecution approached Baker, he was hardly a model citizen. He already had 4 prior felony convictions to his name, he was on parole, and he was awaiting a new charge for grand theft, committed while he was already on parole. And there turned out to be an agreement. In exchange for his testimony against Occhicone, the prosecution would recommend Baker receive probation for that new grand theft case instead of prison time. And so it went. Baker received probation. But during the trial, under oath, Baker testified he did not have a specific agreement with the prosecutor about his sentence in that grand theft case. Years later, a judge in the state proceedings found that testimony had been untrue. The public records of Baker's own grand theft case showed he had in fact received probation, precisely as part of his agreement to testify against Occhicone. That is, at its core, exactly the scenario the Giglio Doctrine was designed for. A witness who lies under oath about the existence of a deal when that deal did in fact exist. And yet here too, it did not hold up. Both the state court and, in 2006, the U.S. Court of Appeals for the 11th Circuit rejected this appeal. The reasoning is one we've now encountered a few times, and it's important to understand why. The court acknowledged Baker had lied about the deal, but the question under Giglio is not only whether there was false testimony, but whether that false testimony could reasonably have affected the jury's judgment. The court ruled it could not. Why? Because Baker's credibility was already heavily under fire during the trial. The jury already knew he was on parole. The jury knew he was hoping for a favorable recommendation. And the jury knew he had multiple prior convictions for crimes involving dishonesty. A jury that already viewed a witness with the greatest possible suspicion, the court reasoned, would not have fundamentally changed its mind over that one extra lie about the precise deal. And there was, once again, that other independent evidence of premeditation. In other words, a proven lie by a key witness, weighed away as not decisive. It's an outcome many people will find jarring, and it lays bare one of the most fundamental tensions in these cases, the difference between something went wrong and that error changed the outcome. Courts concern themselves at their core with that second question, and much less with the first. There's another element in this case we can't skip over: the non-unanimous jury. In 2016, the U.S. Supreme Court ruled, in a case called Hurst v. Florida, that Florida's old sentencing system, in which a judge rather than the jury made the final factual findings needed for a death sentence, violated the constitutional right to a jury trial. The Florida Supreme Court applied that ruling and required unanimous jury recommendations going forward, and for a time, roughly 150 people on death row whose sentences had relied on a non-unanimous vote became eligible for a new sentencing hearing, but only if their conviction had become final after June 2002, the date of an earlier related ruling called Ring v. Arizona. Occhicone sought relief on exactly this basis, arguing his own 7-5 recommendation should no longer stand. He was turned down. His conviction had become final back in 1991, more than a decade before that cutoff. It's one of those quiet, technical details that can make the difference between life and death, and that rarely make the headlines, but that turn out to play a surprisingly large role in the practice of death penalty cases in Florida. Beyond the courtroom, there was another route, and it's worth mentioning, because it's been pursued emphatically in this case: clemency. In Florida, the power to grant clemency, to commute a death sentence to something like life imprisonment, lies with the governor, together with a clemency board. It's a purely political process, separate from the courts, and the governor is under no obligation to give any reason at all for a decision. What makes the Occhicone case special in this respect is the role of his faith. Occhicone is a devout Catholic, and in the run-up to his execution date, he received open support from religious leaders and Catholic organizations that oppose the death penalty. They point to the Catholic teaching that human dignity is never fully lost, even in someone who has done great evil, and called on the governor to spare his life. Petitions were launched, and calls were made to the governor's office. A Catholic priest who has ministered to death row inmates in Florida for years gave voice to a broader concern shared by many opponents this summer. He asked aloud whether the current pace of executions aimed at ever older and sicker prisoners might be deliberately intended to prevent a natural death from letting someone escape execution, and he added that executing the most frail and elderly prisoners, in his eyes, only makes the cruelty greater. That kind of public pressure rarely changes the outcome, but it belongs to the complete picture of how an execution unfolds in America in the weeks beforehand, not only in the courtroom, but also in public opinion, in churches, and ultimately on the desk of one politician with the final authority to decide. And then we come to the events of this summer. In late June 2026, Governor Ron DeSantis signed the death warrant of Dominick Occhicone, with a scheduled execution date of July 28th. It was at that point the 12th death warrant DeSantis had signed that year. To put that in perspective, Florida finds itself in what you could fairly call an unprecedented pace of executions. Since DeSantis became governor in 2019, 37 people have been executed in the state up to Occhicone. They spent, on average, more than 30 years on death row before being put to death, and their average age at the time of execution was 60. Only 5 of them were older than 65, and all 5 were executed only in the past year, which shows how recent this trend of executing very old prisoners actually is. Occhicone's death warrant was signed by DeSantis one day after another prisoner, Dusty Ray Spencer, was executed at the age of 74. At that moment, the oldest person ever put to death in Florida. And if Occhicone's execution goes forward, that record shifts again and much further. Occhicone is 80 years old. Take that difference in. Within a matter of weeks, Florida saw the record for the oldest person executed in its own history move to 74, and now possibly to 80. It reaches beyond Florida, too. Occhicone would, if it goes forward, be only the second person over the age of 80 to be executed in the modern history of the United States. That's no coincidence. It's the direct result of the fact that a large share of the people sentenced to death decades ago are now simply growing old enough to make a question unavoidable. At what point does someone become too old or too sick to still be executed? Because the man Florida wants to execute is no longer the man convicted 40 years ago. According to his attorneys and the organizations working on his behalf, Occhicone suffers from heart disease and kidney disease and has impaired vision and hearing. He needs help with the most basic daily tasks: climbing stairs, getting in and out of the shower. His attorneys state that prison staff will have to help him as he crawls onto the gurney where his life will be ended. After signing the death warrant, Occhicone filed his 6th and final successive motion for relief. His attorneys argued that, at his age and in his condition, he would not be able to undergo the execution in a humane way. They pointed to his chronic conditions, his insomnia, and the aftermath of years of substance abuse. But their most striking argument was about the execution drug itself. The first drug in Florida's 3-injection protocol is a sedative called etomidate. And here something unusual is going on. In April of this year, the American Professional Society of Health System Pharmacists reported a nationwide shortage of etomidate and said hospitals and emergency medical providers have to limit their use of it. Because etomidate isn't only an execution drug, it's also used in the emergency room to quickly sedate patients without dropping their blood pressure. A life-saving drug, in other words. Occhicone's attorneys argued it is indefensible for the state of Florida to be stockpiling this scarce, life-saving drug for executions, while hospitals and intensive care units run short of it treating their own patients. They argued that using this drug to execute a nearly 81-year-old frail man, while it's needed elsewhere to save lives, cannot be justified in principle. They asked the court for a stay until there was no longer a documented shortage. There was a second layer to the objection to this drug. The claim that etomidate doesn't keep a prisoner unconscious long enough, and that the combination of drugs can lead to pulmonary edema, where the lungs fill with fluid and a suffocating, drowning-like sensation arises, while the prisoner may still be conscious. And there was even a third, unusual argument, one that says something about how heavily this high pace of executions now weighs. Occhicone's attorneys argued that the prison staff themselves are suffering under this string of executions, that the people who have to prepare a fellow human being for death over and over, and who after the injection have to touch a frail, elderly prisoner's face and call his name to check whether he still responds, suffer psychological and moral injury from it. It's a striking argument, and it underscores how much the current pace has an impact reaching far beyond the condemned man alone. The courts that have heard these arguments so far have rejected each one, describing them as untimely, procedurally barred, and without merit, language that shows up again and again in these late-stage capital appeals. As of this recording, no stay of execution is in place, and the execution date stands. And then there's the detail that would make this execution a grim first. On that same July 28th, a second execution is also scheduled in Florida, that of another condemned man, earlier in the day. If both executions go forward, it would be the first time in Florida's history that the state executes two people on one and the same day. That's the context in which the final days of Dominick Occhicone unfold. Not only a possible record for the oldest person executed, but also a double execution, unprecedented even by the standards of this extraordinary summer. As of this recording, the execution has not yet been carried out. It's scheduled for July 28th at 6 p.m. If you're hearing this in the days right after we publish it, that date most likely still lies ahead of us too, and we don't yet know how it will end, any more than you do. What we can establish is how much this case shows how much can remain unresolved in an American death penalty case, even decades after a conviction that was affirmed at the time by the highest court of the state. A key witness who lied under oath about a deal with the prosecution, a prosecution expert who, with the knowledge of hindsight, revised his opinion, a non-unanimous jury recommendation that could have been invalid under later rules, were it not for a technical cutoff date. And now, decades later, a defendant whose own physical decline has become part of the legal argument against his execution. We want to draw a clear distinction here between two kinds of doubt. The one kind is about whether Dominick Occhicone is responsible for the deaths of Martha and Raymond Artzner. On that, based on what we've been able to find, there is no substantial evidence of innocence. There was a dying man who named him. There were the threats beforehand. There was the cutting of the telephone lines. The other kind of doubt is about something entirely different. Whether the trial that led to his death sentence was entirely fair, given a witness who demonstrably lied about a deal. Whether the death penalty was the right outcome, given a non-unanimous jury recommendation that today, under the current rules, would not on its own be sufficient. And whether, after nearly 40 years, and given the condition he's now in, it's still the same man and still the same sentence being carried out here. That distinction between guilt for the act itself and the question of whether everything around it was fair and proportionate is exactly what American death penalty cases have to grapple with again and again. And it's exactly the distinction we try to keep clear in this podcast, case after case. And what we want to emphasize here too, finally, No outcome brings Martha and Raymond Artzner back. No outcome undoes that night in 1986 or the 40 years that followed. What this case above all lays bare is how long the American legal system can take to close a case, and how much can remain uncertain along the way, even when there is, as here, a confession. Follow the news in the coming days, and we'll keep you informed of how this case ended. That was the two-part case of Dominick Occhicone. Next week, we begin a new case.